Well, good morning. Thank you very much for joining me in this video. I want to talk to you today about dispute resolution. When we think about dispute, often we think about two agents that are kind of duking it out over commission. It may be something like one agent was looking after another agent's work, and they thought they'd do it on a 25% basis. But one agent understood that he was going to be paying 25%, and the other agent thought he was going to be paying out 25%. And so there's a 25-75% swing. Generally, that type of dispute is within an office, and it's handled within the office. And the broker will sit down and they'll try and mediate and work it out. Often, though, it's between brokerages. It may be a co-brokerage situation where two people listed a property. It could be a dispute over expenses. There could have been a shortfall in commission, and the one office isn't happy about how the other office is handling it. Or it could be that the buyer was under contract and never disclosed that information even though they were asked. For whatever reason, one party feels that they're not getting the commission that they're entitled to. Now, if it's within a board, it's under ITSO. But if it's even between boards, if those board members are both members of ITSO, then the requirement is that it's filed for arbitration. Arbitration, the complainant would fill in an application form and send it off to ITSO. And I want to point out that it has to be done by the broker, even though the broker is not one of the players. It's between brokerages, it's not between agents. So he tells the story. He provides also a $1,000 filing fee. He submits it. Then ITSO takes that information, sends it to the other party, and they have an opportunity to respond. One thing you need to know in this arbitration process is that it's mandatory that it goes through mediation first. And mediation is an informal process rather than the arbitration hearing, which is much more formal. If I can compare it to the legal system, it's a preliminary hearing where two parties are going to be going to court, but beforehand they sit before a judge, they have an informal hearing, and the judge lets people know what he thinks about it, how he thinks it's going to go, and tries to stick-handle a solution. So if under arbitration they can come up with a mutually acceptable solution, then the person who filed the complaint gets his $1,000 back, less some expenses. And that's the arbitration process. Now you can download the whole arbitration process off the ITSO website, and certainly if you're going to go that route at some point in time, you'll need to do that. Then there's a level of consumer complaint. This is where a client is not happy, and they may phone the brokerage. If they phone the brokerage, the broker or manager will talk to them and try and let them vent their concerns and try and solve the problem as best they can. More often than not, however, the complainant doesn't go to the broker. He goes directly to RICO and he files a complaint. Anytime RICO gets a complaint filed in, they get a hold of the person who is the defendant, give them a copy of the complaint, and require them to respond. Let me take a couple minutes and talk about that process. I want to say, and I understand this video is going out to more than just a local group, I got to be careful what I say, but RICO is not your friend. Understand that the Real Estate and Business Brokers Act 2002 is consumer protection legislation, and RICO is on the side of the consumer. What they're going to try and do, and I think they're fair, I think they're working very hard at being fair, but they're trying to do is find out whether there's enough wrongdoing to justify taking you to court. And so RICO is the prosecuting attorney. Keep that in mind. When you respond, tell a story. When I say tell a story, I don't mean a fictional story. I mean a factual story, but walk them through what happened. Say, I received a phone call from the clients at 23 Maple. They've been my clients for a long period of time. I attended the property, and you explain step by step what happened. When you are writing this narrative, look at the complaint and make sure it addresses each one of the items that the person complained about. They may say, the agent never communicated with me. And you could say, in their complaint, they said, I never communicated with them. That actually is not true. I communicated numerous times, and I am providing a copy of the text messages that we sent back and forth. And so you address each one of the items that they complained about. You're also required to provide all documentation. They want a copy, depending on what the complaint is, they want a copy of the listing, a copy of the agreement of purchase and sale, a copy of the amendments, and all kinds of things that would support that transaction. You also want to add things, like I said, with the printout of the text messages going back and forth, you want to add any supportive documentation too. Having said that, let me say, do not admit liability. Don't say in your response, gee, I really screwed up there. Let them figure that out. Don't say that. And it may be that you screwed up somewhere, but it isn't the direct issue that they're looking at. They may be looking at the way the offer came down and the conditions that were in the offer, and the person may be saying, you didn't protect my interest by not including a condition on sale of property or something. And you may realize when you go through your paperwork that one of the amendments or one of the waivers was actually done after the deadline. Don't bring that up in your response. That'd be like driving along on the highway and being pulled over for speeding, and the police officer comes to your window, asks for your license and registration, and you say, no, I want to make sure, officer, that you notice that my sticker on my plate is overdue. Let him discover that. Don't bring that up. And that's why I say when you're dealing with a RICO complaint, run it by me. I want to make sure that you've covered the points, you're sending the material you should, but you're not sending material you shouldn't. Keep in mind, they're the prosecuting attorney, you're the defendant. And then there's the third thing, and that's litigation. That's where we're actually being sued. And here we involve errors and omission. Now, because the errors and omission insurance is governed by RICO, agents get confused and think that this is the same as a RICO complaint. It is not. RICO is the prosecuting attorney. Your errors and omission people are your defense attorney. Now, it's at a different level. It's going to court, but you say anything you want to them. Say, I really screwed up here, or I shouldn't have done this, I want you to notice. You want to make sure they've got the full picture. They're not going to take things that you've done wrong and send it off to RICO. They're on your side. So you want to be thorough with them. But the other thing I want to point out with errors and omission is that although it's the benefit of first dollar legal defense, that means that the legal costs they're going to absorb, they want to make sure that the first time you even sense there might be a problem, you notify them and they open a file. If you don't, and you don't tell them until we get served papers being taken to court, and they discover you knew about it 6 months ago, they have the right to not protect or not represent you, not cover you. Because they're afraid that during that 6-month period, you've said things to dig yourself deeper. And when you do open a file, if nothing comes of it, there's no penalty to you, but you're covered in the event that it does move forward to a legal process of being served a lawsuit. Let me say one other thing about a whole process of errors and omission insurance and so on. They will cover where you're being sued, but they won't cover a commission dispute. And sometimes the seller is mad for some reason or other, and the commission is $30,000, and he's just going to withhold $30,000 from the commission. And so it becomes a commission dispute. Errors and omission won't touch it. If you got $30,000 in deposit, and therefore he can't withhold it, he's going to sue you for $30,000. Now errors and omission will cover it. So they'll cover a suit, they won't cover a commission dispute. So it's important how the thing's structured moving forward. But it's important also that you make sure that you notify them right away. And you want to be covered, and the extent of exposure under errors and omission is $2,500. In other words, you pay nothing for the legal defense, and if the ruling, and it can be in preliminary hearing, if the ruling is that they're going to be awarding the complainant, let's say $30,000, they will come back to you for $2,500. You won't be on the hook for $30,000. So the errors and omission insurance is a wonderful thing to have in place. Make sure you follow the rules. I hope this makes sense. Hopefully we don't have disputes. Hopefully we don't have agent to agent, office to office, board to board level disputes, consumer complaint disputes, but we need to be prepared and know how to handle it if we do. I want to thank you very much for joining me in this video. I look forward to talking to you again next week.